Here come the troops. Here come the litigators, Deborah and Matthew. And, actually, before you start, I was reading through the Q&A, the questions, so please turn in some more if you have them, just a moment ago. And someone asked a question that I've never had asked before, and I love it, and it relates to this panel. And so I thought, I'm going to take it early. I'm going to take this question early. The question is, when a memo is issued, does it go into effect immediately, and is it basically law? Okay, that's a great question. It's a constitutional question. And so I'm going to give you a quiz the way Bob gave you a quiz. And I'm going to ask you 3 questions that often get asked of people applying for citizenship in the United States. They go to an interview and they get asked a set of questions. And so the first one is, who makes the laws?
Congress.
Congress makes the laws, right? What is the executive branch's role? To enforce and to implement the laws, right? So an executive order is supposed to be related to existing laws in some way, right? And if it isn't, it's ultra vires, it's outside of the laws and regulations. So what do the courts do? Interpret and bring us back to where we were, where we're supposed to be with these 3 branches of government. So the courts will decide in this context if the executive order goes beyond the scope of what Congress has determined are the laws. So just a little bit of a reminder here. I had to put back on my law professor hat. Both of those 2 up there were my students, by the way, years and years ago, for Deborah in particular, and quite a few years for Matthew. So I thought this was just a good segue right into it. Well, you look so young, Deborah. Come on, So I thought this was a great question to lead into your panel. Thanks.
Yeah, thank you.
Thank you. I was pretty concerned we were going to be graded on this. Bring back my memories. Because I was saying, wow, she still has that law professor. So we're here to talk about what most companies don't want to ever hear the word, litigation, right? It's what you want to avoid for lots of reasons. It's expensive, it's stressful, and it interrupts your business, right? It's not something you want to look at. But in what we've seen in this environment, it's actually maybe where many of you may be going in the future. Because actually Laura laid it out well in talking about how do we enforce our law. Well, what we're seeing is Congress is inactive. We're not seeing legislative reforms to add H-1B numbers. We're not seeing protection for workers. We're not seeing immigration reform being passed. We couldn't even see DACA implemented, even though there is a whole support and timetable. We have an executive branch that is looking at ending immigration, legal, illegal, really an attack on what we've found America. And so what do we have left? We have the courts. And so that may be our last arena to go to make sure that the laws as written are being enforced and that the needs of the American people and our companies and our foreign nationals here are being protected. And so we're going to talk about some avenues that litigation is being pursued and ways we may think about going there. One of the ways companies are going to be involved in litigation is because of the increased rate in denials. I think Lon had pointed out that we had less than a 60% approval, not our group, but overall, that there's a less than 60% approval ratings for H-1Bs. If that trend continues, that's going to be incredibly damaging to businesses and the economy for key skilled workers that they can't find otherwise. So if companies don't push back and challenge this, this is going to be the status quo. So we're going to talk about when does litigation make sense for you, why you would choose to pursue it, and how do you move forward with that type of litigation. We'll also talk about some cases that we've seen that have been successfully done by other businesses and kind of how other companies can now use that as precedent in going forward and supporting their own cases, and then how you can assist. If this is something that your company ultimately decides is right, how we can help move you forward. Okay, so first thing I'll talk about is before you get to litigation and if you get a denial, where you're looking at. So immigration is conducted mainly through administrative law. When you're filing petitions, you're filing with an immigration agency, but they're not the sole decision makers. If they deny, the next step is how do you go above them? What's the next group above that? And that's the Administrative Appeals Office. So under most applications, you do have the right to appeal the service center's decision. So you can appeal denials of non-immigrant visa applications and employment-based immigrant visa petitions that have been filed. You can also file a motion to reconsider. So you have a few options. You can go back to the same officer that reviewed your case and say, look, we'd like you to reconsider your decision. We believe it was wrong as a matter of law for the following reasons. Or you could say, we'd like you to reconsider, and then it'll automatically be sent to the Administrative Appellate Office where you want a different group of adjudicators to evaluate the service center. In, I'll say the old days, I can say old now that Laura's outed me at my age, we had very few denials. And so when you actually filed an appeal, it was kind of exciting and pretty much almost won them because it had to be pretty egregious if we were going to go down to that appellate path. These days, the Administrative Appellate Office is fairly much rubber stamping the service centers. They've really gotten into cahoot with each other, and they're giving them a lot of deference. And so using that avenue is becoming less and less attractive. And it's taking a long time. While they have a promotion of 4 to 6 months, in some cases it can take over a year to hear back. And all you're going to wait is a year. It does not toll the time of the presence for your employee. It does not give them the right to keep working while you're fighting this. So it's not, in many cases, the best option for proceeding. In some circumstances, USCIS itself will certify it to the Administrative Appeals Office when there's an unusual or complex area of law. For example, these precedent decisions that we're seeing is because they want to now interpret the law in a particular manner and have widespread authority. So why would you go to this administrative appellate agency, right, if they're really not going to look at your case? Well, it does give you an avenue to supplement your record. So say you prepared what you thought was a great petition, but you realize, you know, we have some more supporting documents we could put in. We really think we could substantiate our argument. You may want to go to the AAO because you can add to the record. Or you feel if it was just one minor error and they didn't look at it or they didn't see it a certain way, you believe you'll be successful on a motion to reconsider, then you may want to go ahead and refile because the cost is not very high. There's a filing fee and obviously the legal argument attorney's fees, but it's not that any more than you filed with your initial application. So why wouldn't you appeal? Again, you're likely going to get rubber stamped. In many cases. They may deny you on a ground you didn't even think of, okay? So they have de novo review. It's not arbitrary and capricious as when you get to the courts that we'll talk about. They can say, well, you're right, the service center completely ignored your 5 pounds of evidence, and it is a specialty occupation, but actually, we don't think this degree qualifies, so we're denying you. And you didn't even get a chance to argue that decision, right? So they're going to undercut your evidence on their own merit. And how long it takes, a long time, and if you need to invalidate USCIS policy. And what that means is if you want to challenge their memo, if you want to challenge how they're interpreting law, you don't want to go to the agency, you want to go to a federal court. You want the district courts involved who are really going to have authority and to tell an agency, look, we can't give you deference because the analysis you're using is incorrect as a matter of law.
And that kind of ties in with Laura's excellent intro, right? We have these 3 branches of government, and the AAO is still within the executive branch. So you're still kind of just going within that. And so now we're going to talk about jumping ship and going to a different branch. So again, if you're going to challenge a policy of the executive branch, you can't do that within the executive branch. Obviously, they're going to say, that's our policy. We want that policy. So you have to go outside of that. Some reasons why lawsuits might make sense now, and I think why you're seeing more of them kind of in the public arena that are being talked about in newspapers and you've seen on the news in the immigration sphere, is that the denial rates have increased. The denial rates and the RFEs have increased. As Lon said in her presentation, they increased 44% year over year in 2017. So a lot more of the RFEs. So, you know, orange is the new black. I think RFEs are the new approvals and maybe denials are the new RFEs going forward. We've seen an increase of denials just across the nation. L1Bs, for example, this is going to go back a few years, but in 2008, the denial rate was about 10%, and in 2015 they were 35%. So again, that's kind of multi-years during the Obama administration. We don't have newer numbers, but our sense is that that's increasing, and that's one specific type of visa, the intra-company transfer. But you've got lots of pressure on these specific visas. So the denial rates have increased. Again, there's kind of this lack of deference to the initial approvals. Again, that was talked about in a previous presentation, where your extensions, they're going to get a de novo review. They're not going to give deference to the fact that this person has been working at your company under the same visa category for 10 years. They're going to look at it again and might deny it. So that might, if that were to occur, it could have serious repercussions. If the individual has a perm application, they have a pending I-140, they've been with you for a long period of time, and they're really just waiting for their number to come up. If they were to be denied, that has serious ramifications for that individual. And if they're a key employee in your company, a huge ramification for you as well. You obviously were planning on this person to be here. You've gone through all those steps to keep them here for 10 years, and now you get a denial. Also, the types of cases being denied, I think, makes litigation more likely. Again, you have a lot of higher level individuals. A lot of the pressure has been on computer programmers and computer professionals, which could be higher level individuals. You've got economists. There's a lot of pressure on them, which again could be higher level individuals, key people in your company. That might make speedy resolution through litigation a better option for you. We've also seen other types of cases being L1As being denied and L1Bs being denied, and H2Bs. Deborah, any other examples of kind of increasing denial rates that might drive litigation in this new atmosphere?
I get nervous, hope not. But one thought that we've seen is really because of the lack of deference, where litigation may come into play are employees who may be from India or China subject to backlogs, and they've been your employee, they're already on their 7th or 8th year extension. And for the first time, you filed to extend again, and USCIS denies, right? They've challenged you and said, oh, really? We don't think it's a specialty occupation. He's been in this visa status for, 7, 8 years. You've proven you can't find qualified workers by doing a labor certification. You have an approved immigrant visa, and now that they're taking it away and you're forcing this individual to go home, this is the type of, I think, case that would be ripe for adjudication. This is the kind of case that you may want to stand behind in addition to the ones previously entered. And really, even if it's not a widespread category, any denial that impacts you that you were willing to commit to is worth evaluating your next steps and going forward as part of your strategy of, well, we still need this person to join us. How do we get her on?
Excellent. So the next step is how to assess if litigation is the right step for you as a company. One of the things that Deborah previously talked about is kind of the basis of the denial. Is this a reasoned decision, or is it arbitrary and capricious, which is the standard of review in the court system? Sometimes you look at these RFEs or you look at these denials and it's like, I don't recognize that employer. I don't recognize that employee. And sometimes it is not your employee. Sometimes the analysis and the denial is for someone else, and it does not match the application you put together. It doesn't match the huge stack of papers that you filed. They got cases mixed up, or they are reviewing it under the wrong standard of review or the wrong regulatory requirements. We'll talk about this in one of the recent case examples, but if they're consistently citing the wrong regulation, that might make litigation make sense, because again, the AAO is probably going to rubber stamp it. They have a high affirming rate, and so it might be much faster to go to the federal courts to get a review of that. Another question you want to ask yourself is, can I refile, or is there some alternative? Is it time sensitive? Is it going to have harm to this individual's derivatives? Is it a cap case, right, where the individual, they're going to have to wait a whole nother year and they might run out their OPT, or as Joseph talked about, the STEM OPT, they might run out that entire period of time and they really need this application to be granted. They don't have another shot. And is it the right time, obviously, for you as the company to make a stand? Some of that might really depend on this employee. Again, we're seeing challenges to whole categories of employees. So it might not just be, if it were a situation where they were challenging a specific position in your company and you have 50 of those positions, this is going to be a big deal for you as a company, right? It's not just a one-off, I really want to help this employee, which, it could make sense for you as a company. But if it is a key position or one that you have a lot of in your company, it might make a lot more sense to litigate that so that you can get a ruling on that specific position. And then you have precedent to say, this position is a specialty occupation, and that'll kind of protect the analysis and give you a peace of mind going forward with your employees. You have this great decision for this position. In terms of the life cycle of immigration, we'll just talk about this briefly, but this is not kind of your Perry Mason, Matlock, Law and Order type of litigation. There's not a lot of fist pounding and table thumping. This is mostly submitted on the paper. So again, in terms of litigation, this is fairly low dollars. It's not kind of your extended trial by jury. You don't have a jury involved. It's all adjudicated by a judge. And it's, again, mostly on the papers. So it begins with filing a complaint in federal court, and it can actually begin before that. Sometimes, again, kind of in other spheres, just simply sending a complaint and saying, we're going to be filing this, is enough to get some traction. And we've heard of some success of sending that and essentially saying, we really want you to reconsider, we're prepared to file this. And we've heard of some success nationally on that. Again, you have to go through the process of drafting it and be prepared to move forward with it. But you could have some success before you even pay the filing fees here across the street at the federal courthouse. But that then is the initiation of the lawsuit with the complaint, and then it very quickly would move to a motion to dismiss, that the government would move to dismiss the case, and then it essentially becomes a motion for summary judgment. You have all of the record. Again, you've put in all of your great evidence, you have all this documentation, and that's really what the case is going to be decided on. So you don't need to develop a fact record. You don't need to bring in all these witnesses. It's really, here's all of the facts, and here's the laws applied to the facts. So again, it's a pretty streamlined process, and that's typically, that's how it's going to be resolved. Before coming to Fredrikson, I clerked at the federal court, and we saw only one case there while I was there. But again, it was very streamlined, and we saw a motion to dismiss. I think that, again, it's becoming more common now, and it really is an option for employers to challenge and kind of get outside of the executive branch and get an adjudication by a judge. In terms of some recent successes, we'll start off with one here in Minnesota, the Kessens case. This was a case that was filed with federal judge Pat Schiltz, and it was an H-2B case. It was initially denied, but the AAO, the Administrative Appeals Office that Deborah talked about, reversed itself after the lawsuit was filed. So this is a little atraditional. The employer filed an appeal with the AAO and also filed federal litigation. It's a little complicated, but there's not an exhaustion of remedies, and you can kind of go down two paths at the same time. And so they did both, and the AAO thought better of its past decision, and instead of getting a bad decision in a federal district court with a written opinion that goes on to Westlaw and everyone can access, they reversed themselves and quietly put it away, and the employer got their employee through. So that sometimes happens, and again, is kind of a tangential benefit to litigation. You don't always have to win with a written opinion from a judge. Sometimes you can win by influencing the other side. There's also a 2005 decision in the Button Depot case. Again, this is an H-1B denial that was overturned. And the reason it was overturned was because consistently throughout the decision denying the H-1B, the examiner was citing to the wrong test again and again. And so again, applying the wrong law to your case is a great reason to go to federal court. And here that was resolved at federal court. That was a California case. Then the last case we'll talk about is the Next Generation case. This was a 2017 case from the Southern District of New York. And in that case, it was an H-1B denial as well. And in that case, the federal judge found that the officer had disregarded evidence. So this comes up a lot of times where we submit these large packets of H-1Bs and this year submitted even more to kind of try to head off the RFEs. So you've got 200 pages of material and the decision doesn't seem to talk about any of the individual's qualifications and just says this individual is not qualified for the job. It's like, well, what of the 50 pages here does not say that this individual is qualified? And so in that case, again, it was a 2017 case, the judge said, yeah, this decision disregarded the clear evidence that was submitted with the case and kicked it back on that.
So how would we step in if this sounds familiar to many of you and reading about why people have gone to court and where you may want to go? One is talking with us. So hopefully you don't get any denials, but if they do come and this impacts you and your employee, is we can do what I call a risk-benefit analysis. We'll take a look at the petition. Obviously, if we didn't file it, we'll have to review what was filed and say, look, does this look like a winnable case? Should you have won? Or do we feel, you know what, they did have enough reason? Maybe the best strategy is to refile, premium process, and get a decision right away. And we provide that assessment. And many times that is my recommendation because we feel you can always second guess yourself and think, maybe I could put something more in. And so you want to have the best record going forward. But maybe for the many reasons, you're capped subject, there's no other option, it should be pursued. And then look at the cost. So an interesting thing about litigation, as with H-1Bs, as you know, it's an employer expense. But litigation is different. You've already paid for the H-1B. There's no requirement that it be an employer expense. It could potentially be a shared cost between the employee, the employer, or even a third party. Because you're really outside the administrative arena at that stage and going into federal court. It could be something that your general counsel is interested within your business. If you have attorneys on staff, they may want to take this forward themselves. They may have their own litigators who are happy to call in. And sometimes just starting the case may get immigration to, oh, wow, they actually are serious. You have a lot of power and attorneys behind you. We're going to relook at our decision because maybe we didn't look at it carefully enough and we need to reopen it. And looking at the timeline, these can move pretty quickly, faster than we can sometimes get H-1B decision results back. So, much faster than going to the administrative appeals office most often. And it may be worth it for the right employee and the right decision. And then looking at strategy. Are there others who are facing similar? We work with lots of national organizations who will partner with many businesses because they're basically nonprofit staff to do employment-based litigation. Their goal is to make sure that our government and its agencies are following the law. And so you won't be in this alone. We can help you assist with partnership to move this forward.
Yeah. Yeah, and like Deborah said, I mean, a lot of nonprofits are interested in these cases, but they don't have standing, and so they're looking for employers that have been affected by the laws to then challenge it, and so they can partner with you. We also wanted to throw out, Fredrikson and Byron has over 80 attorneys in our litigation group, so we are well staffed with that as well, and we have some experience in the immigration litigation group as well, kind of on immigration.